Imagine you are standing in a courtroom where time, liberty, and credibility are all on the line. The Sixth Amendment exists for this exact moment. It is the part of the Constitution that defines what a fair criminal prosecution must look like. For lawyers, it is not theory. It is the operating system of criminal defense and prosecution. The Sixth Amendment guarantees the rights of the accused in criminal cases. It promises a speedy and public trial. It promises an impartial jury. It promises notice of the accusation. It promises confrontation of witnesses. It promises compulsory process to obtain witnesses. And it promises the assistance of counsel. These rights were not invented casually. They were reactions to abuse. Colonial Americans had lived under British courts that delayed trials indefinitely. They faced secret proceedings and hand-picked juries. They were denied lawyers and blocked from calling witnesses. Justice was slow, opaque, and tilted toward power. After independence, the framers wanted guardrails. The Bill of Rights was ratified in 1791. The Sixth Amendment was one of its most practical guarantees. It was written to control procedure, not ideals. It told courts how to behave, not how to feel. The term Sixth Amendment itself comes from ordering, not hierarchy. It was simply the sixth proposed amendment adopted into the Bill of Rights. But over time, the phrase became shorthand for fairness in criminal law. When lawyers say Sixth Amendment issue, everyone knows the stakes. Let's break down the core rights, starting with a speedy trial. Speedy does not mean rushed. It means the government cannot stall while a defendant waits in limbo. Delays can destroy evidence, memory, and lives. Courts balance length of delay, reasons for delay, and prejudice to the defendant. Next is the right to a public trial. Justice is meant to be visible. Public trials discourage abuse behind closed doors. They allow accountability for judges, lawyers, and juries. Transparency is a feature, not a risk. Then there is the impartial jury. This is not about perfection. It is about neutrality. Jurors must come from a fair cross-section of the community. Bias undermines legitimacy faster than almost anything else. The Sixth Amendment also guarantees notice of the accusation. A defendant must know what they are being charged with. Vague or shifting accusations are unconstitutional. Preparation is impossible without clarity. This right forces the government to show its hand. Confrontation of witnesses may be the most litigated clause. The accused has the right to face those who testify against them. Cross-examination is the engine of truth in adversarial systems. Hearsay rules grow out of this guarantee. If testimony cannot be tested, it cannot be trusted. Compulsory process gives defendants power, not just protection. It allows them to subpoena witnesses in their favor. The defense is not limited to reacting. It can build its own case. This levels the playing field against the state. Finally, the right to counsel ties everything together. Without a lawyer, the other rights collapse. This right was not always interpreted broadly. Early courts allowed trials without attorneys. That changed over time. In Gideon v. Wainwright, the Supreme Court made it clear. The right to counsel applies to the states. Indigent defendants must be provided an attorney. This case transformed criminal defense in America. It also placed massive responsibility on lawyers. For modern lawyers, the Sixth Amendment is alive. It shows up in motions, hearings, and appeals. It governs discovery disputes and trial strategy. It affects plea negotiations and post-conviction relief. It is always present, even when unspoken. But the practice of law has changed. Cases move faster. Clients expect instant updates. Courts demand precision and deadlines. Lawyers are expected to be ready anywhere. This is where legal tools enter the picture. Technology does not replace constitutional knowledge. It supports it. It helps lawyers execute rights in real time. Preparation is the modern form of defense. Legalizer is built for this reality. It is mobile-first by design. It treats law firms like operating systems, not filing cabinets. Cases, clients, billing, and growth live in one place. Everything moves with you. For Sixth Amendment work, readiness matters. A speedy trial claim depends on timelines. Legalizer helps track dates, continuances, and delays. A missed detail can change the analysis. Having records accessible instantly makes arguments sharper. Public trial issues often involve logistics and access. Court appearances, filings, and notices must be documented. Legalizer centralizes communications and case history. That transparency mirrors the values of the amendment itself. Jury issues require organization and recall. Voir dire notes, juror profiles, and strategy evolve quickly. Mobile access keeps information available in court. Preparation builds confidence.